Good afternoon. My name is Howard Williams. I'm the Continuing Education Coordinator and Head Instructor here at Alpha College. Today, I'm going to talk to you about Chapter 7, which is Fair Housing and Agency in our Principles course. I want to go over some points that I found in the past that students may have had some issues with. Um, I won't be doing the whole chapter page by page per se, but I just want to point out some things. Uh, Agency really is the backbone of what we do in real estate. It dictates what people are to us. In essence, our agency, you have to answer the question, uh, who are you and what are you to me? Meaning everyone to you has a role to you in a transaction. And you have to determine who they are to you. Because fortunately, people are only two things to us. They're either our customer or our client. And the hard part is figuring out which one you are. Because once I figure out which one you are, what I do for you is already pre-written. So the bottom line is, who are you and what are you to me? So let's talk about how we get to that point as we get started. For the first part, we have to understand what agency is. And agency is when the principal delegates to another person to right to act on the principal's behalf. So a principal to us is a client. So the short version, when someone says to a licensee, represent me. And when that person tells you to represent them or that party, then they are your client. So in every real estate transaction or every deal or what we call a transaction, there's three parties. There's the principal, who is the client, there's the agent, who is the firm, and then there's third parties. Now, third parties are customers. They're people who are not clients in the transaction. It's who you consider to be your third party. That's who they are. So let's go back down and break it down to who's who. So you're either my principal or my customer. Now, to make sure we have to understand the difference between a principal or a client and a customer. So the basic difference is, let's understand what a client is. So when we say client, we mean principal, and principal is your client. They're interchangeable. They're the same thing. Your principal is your client, the client is your principal. They're the same thing. So if you're my client, if you're my principal, then I work for you. Whenever I work for you, I'm able to give you advice. And in a typical real estate transaction, my principal can be either a buyer or a seller. It depends on who I represent in that transaction. So as we're looking upon the screen, we see that a client is the person who I give advice to. And the client is the principal. I work for you. I look out for you. I put your interests above all others if you're my client. If you're not my client in a transaction, then you're my customer. Customers are not people that I work for. Customers are people that I work with. In a normal real estate transaction, if I work with the buyer, then the seller is my customer. Or if I work with the seller, the buyer is my customer. A customer is anyone who is not my client. Again, a customer is anyone who is not my client. So we've figured out for clients we give advice to. For customers, we do not give advice. We give customers information. We cannot give customers advice. So looking at the two side by side, let's take a look at it. So in every real estate transaction, you're either my client or my customer. We've established that. And if you're my client, I give you advice. My client is my principal. I work for them, and depending upon who I represent in that transaction, it can be the buyer or the seller. Customers are people I give them information to, meaning I don't work for them. I just work with them in the transaction to make sure we get to a closing. And at the bottom, you see EE. EE is everybody else in the transaction. So you may have the buyer and the seller, then everybody else is a customer, such as the bank. The lender would be a customer. The termite and moisture person would be a customer. The home inspector would be a customer. The bank would be a customer. Anybody who is not my client is a customer. Any inspectors, home builders, anybody else that's not my client is a customer. Now, it may seem pretty easy as you look at it on the screen about this advice information scenario. That's when agents tend to have a hard time in how do I determine, Howard, or when do I have to determine whether a person is a customer or a client? Well, let's talk about that. In essence, everybody you meet is a potential client. In real estate business, we want clients because that's who we're loyal to. That's who we look out for. They're a large part of what we build our reputation on because we take care of them. One of the unique things about real estate is that in any other profession, if you said to someone that you're my customer, then people consider that a good thing. If you go to the grocery store, if you go to a restaurant, and someone says you're my customer, you feel good about that because you feel they're going to take care of you. But that's the opposite in real estate. We don't take care of customers. We take care of clients. We don't do anything illegal or unethical to customers, but we do not look out for them. We do not. We look out for our clients. And one of the hard things is for the public to understand that being a customer is not getting our best service. In essence, maybe getting our minimum service. So, the problem arises for licensees is when they give customers client level information. That's when the problem, giving customers client level services. So how we keep from doing that is simple. As long as someone's asking me general questions, this information, let's say stuff that you can open a magazine and see, or something that we have already in the MLS, such as this is a 3-bedroom, 2.5 bath house. Seller wants 350, it's 2,800 square feet. That's information, that's public information, easily found on any website. But if that same person asks me, says that, Howard, will the seller take a lower price? Or Howard, will the seller pay closing costs? Then you're asking for my advice and my judgment. And the only parties that I can give my advice to and my judgment is to clients. So if you're not my client, I cannot give you that advice or my judgment because you're asking my opinion, judgment, advice, which I only give to clients. So the problem arises when agents give client level services to customers, which is illegal. Can't do it in the state of Virginia. Can't do it. So if you ask me general questions, I can tell you. But if you ask for something that requires my judgment advice, you need to be my client. And at that time, we need to stop. In the beginning, when an agent meets someone or a licensee, they should disclose who they are. For instance, I'm Howard Williams with Batman Realty, I represent the seller. Or I'm Howard Williams with Batman Realty, I represent the buyer. I need to disclose who I am to everybody. Just as I need to disclose to everyone that I am a licensee when I'm dealing in a real estate transaction. You cannot hide your licensee status. So if you are a licensee, whether you're active or inactive, you must disclose to people when you're dealing in real estate that you're a licensee. You have to do that. So your Virginia law book would tell you when do you have to disclose your advice status. It may say substantive conversation, and agents on occasion ask me, when is the conversation substantive or substantive? When are we at that point? We're at that point, my answer is, when you start asking for my advice. That's when we reach that point. So I can talk to you for whether it's 10 seconds or 10 hours and give you all the information you want. But the moment that you ask for my advice, whether it's 10 seconds in the conversation or 10 days in the conversation, then you need my client to be my client for me to give you that said advice. Your text also talks about forms of agency. And as we look back again, we say agency is when one person gives you the authority to represent them. That's what agency is, a relationship. Your text talks about 3 different types of agency relationships that you can have. And the first one is universal. When I think of universal, it means you can represent them in anything which you have been given the authority to. I think of it as a unlimited power of attorney, that you can represent them in anything with the scope of their authority they have given you. That's a universal agency. The second one that we normally deal with called a general agency. A general agency is you represent that party, but you do the same thing over and over again. General is the same thing, maybe one thing, but I do that same thing over and over. Example of that is that you're a general agent of your firm, meaning all you do is list and sell real estate. But once you finish with one transaction, it's on to list and sell the next transaction. You just keep doing that same thing for your firm. You only do one thing, but you keep doing it over and over again, such as listing houses or selling houses. You keep doing the same thing. Also, you may think of it like a property manager who manages a large apartment building. Once they rent one unit out, is the job done? No. It's on to the next unit and the next unit and the next unit. So they're doing one particular thing, but they're doing it over and over again. So to back up a little bit, Universal is like an unlimited power of attorney where anything that they could do, you can do. A general agent is when you represent them in a particular thing and you just repeatedly do that thing over and over again. The last thing we're going to talk about is a special agency, which I call one and done. A special agency relationship is one that's normal in a real estate transaction, such as when I represent the seller and the seller house is sold, then our relationship is done. That's what I mean by one and done. Or if I represent the buyer, and once the buyer closes on their property, then that relationship is done. So one and done is I do one thing for you, and then when that thing is done, then our agency relationship is done. So you need to make sure you understand the difference between universal agency, general agency, and special agency, as there are forms in which we represent parties who've given us the authority to do that. In most real estate transactions, there's two firms in the transaction. There's the firm that puts it on the market, which is called the listing firm. And then there's the firm that finds the buyer, which we call the selling firm. But sometimes in a real estate transaction, the same agent may represent the buyer and the seller in the same transaction. And that's called dual agency. So in dual agency, you have one firm who appoints one agent to represent two clients in the same transaction. So this one agent represents the buyer and the seller in the same transaction, called dual agency. Now, a couple of things about this dual agency that we need to remember. One, we can only do it with the written permission of both parties, meaning the buyer and the seller have both to agree to it in writing, of course. And everything we do in real estate, we need to do in writing. We do not perform any acts unless we've been given that authority in writing to perform those acts. So dual agency is when you represent the buyer and the seller in the same transaction. Now there's an interesting twist to this, is how can you represent two different parties effectively? It's similar to telling two people you love them the same. Two people you love them the same. Is it possible? Yes. Probable? Maybe. Difficult? Yes. When we represent a party, we're 100% loyal to them. But in the dual agency, I'm not 100% loyal to you, meaning I won't do anything to hurt you, but I won't do everything to help you. So I'm giving you not all my skill, I'm only giving you a portion of my skill. Because there's some things I could do that now, because you chose this dual agency, I'm unable to do. In essence, I can't hurt the buyer or the seller in dual agency. I won't hurt them. An example for that is if the seller told me that they would take $3,000 less for their house, and I represent the seller. I wouldn't tell the buyer that. Or if I represented the buyer and I knew the buyer would pay $3,000 more, I wouldn't tell that to the seller because that may hurt my buyer's interest. But if this was the same transaction and I'm representing the buyer and the seller, me knowing the seller would take $3,000 less, I couldn't tell the buyer, even though the buyer wanted to pay $3,000 more. Nor could I tell the seller that the buyer wants to pay $3,000 more, even though I know the seller is trying to ask for $3,000 less, to take $3,000 less. In essence, I can't do anything to hurt either party's interest. So in essence, I'm just kind of looking at them both, having information that will influence their decision making, but because it would hurt my other client, I'm unable to provide that information. Dual agency is legal in Virginia. It is not legal in all states, but it is legal in Virginia. Well, so this high level of service we normally give our buyer and the seller, but in dual agency, I can't get that same high level of service. But we said in dual agency, you can only do it if the buyer and the seller agree in writing. You can only do it then. Now, if they do this in writing, then they've agreed to that level of service, then therefore you should provide it because they agreed to it. They don't have to accept that level of service because it changed your relationship when you first listed the property with the seller, where you told the seller you would do everything to look out for their interests. Now with dual agency, the seller has changed that relationship and changed what they want you to do for them. If for some reason the buyer and the seller does not like dual agency, or if any one of them says no, meaning one could say yes and one could say no, it's still a no. Only if both parties agree in writing can we do this dual agency. But there's another option as well. There's something we have called designated agency. In designated agency, the same firm represents both the buyer and the seller, but the firm will appoint one agent to represent the buyer and another agent to represent the seller. So where in basic dual agency, you got one firm, one agent representing both the buyer and the seller. But in designated agency, you have two agents in there, and each represent their own party. So agent A represents the buyer, agent B represents the seller. That's designated agents, even though both agents are in the same firm. In this instance, the buyer and the seller get full representation. So it's three ways a person can do that. A person can be either a client to us or a customer. And that's important for them to determine and us determine before we start providing services. But once you're our client, we're loyal like little puppy dogs. Our clients, we look out for them. Just like if you ever had a little puppy, if you just brush it away with your leg, it just come right on back. That's kind of like how we are. It has nothing to do whether we like you or not. It has to do with the written agreement we have. We take care of our clients. Your text talks about fiduciary obligations. A fiduciary is a person who you put in a position of trust, is what a fiduciary is. Someone you trust. Let's say like your teacher is a fiduciary, or your minister in your church is a fiduciary. You know, someone you trust. Your accountant, you trust them, stuff like that. But a couple of things are fiduciary responsibility. If you're into acronyms, as your text loves them, is the acronym COLE. C for care, O obedience, A accountability, and L for loyalty. So in care, we take care of our clients, and these are duties we owe to our clients, not to our customers, mind you. So if you're my client, I take care of you. What that means is I look out for your interests. I do things like if I go into your house, when I leave, I lock the door. Don't let the cat out. Put the dog in the garage when I come in, put him back out when I leave. If I open the mini blinds or curtains or turn on all the lights or turn on the heat or the AC, that when I leave, I turn them off. That's a care. Take care of your house. Take care of you and your house. Now, the O is obedience, where we have to look at it a little different. Now, we have a written agreement with our client, whether it's the buyer or the seller, to perform certain acts. And we would do those things that's within the scope of our authority that our agreement has given us. We obey all our clients' instructions, unless they're one or two things, illegal or unethical. As long as our client doesn't ask us anything illegal or unethical, we will abide by their instructions within the scope of the authority we've been given. Meaning whatever the agreement said we can do, we're going to do it. If they say do it. Seller tells you lower the price, lower the price. Seller says you raise the price, raise the price. As long as they don't ask you to do anything illegal, you must obey all instructions. When we talk about accountability, we must account for all the funds and things that are given to us. In the real estate transaction, there are occasions where funds will come through your hands. You must be accountable for them. Know where they are, give everybody the proper notice of where these funds are, who's going to hold them, how they're going to get them out, things like that. And our number one thing when I think of a licensee is that we're loyal to our clients. And we're talking about these fiduciary responsibilities to our clients now, not to our customers. So to our clients, we're loyal. In essence, you could have a client that you dislike personally, but because of your obligations, you're still loyal to them. Or it could be something like your seller is the client, and you and your seller can't get along, but your seller is the client. A buyer comes along and wants to be your customer, and that buyer is the nicest person in the world, sweetest, charming person in the world. But since they're your customer, when it comes to the time of loyalty, your loyalty would be with that client, even if you dislike them. Our love of loyalty has nothing to do with how we feel personally about a person. If there's something about that person that we just cannot feel we can work with, then we should just send the transaction back to our broker and not deal with it at all. So we must be loyal to. And as your test may question you on that loyalty, but I want you to remember this. Once you become my client, you're always my client. Forever. Anything that you tell me personal and confidential, I take to the grave. I can never tell anyone anything, no matter what phase of the transaction we're in, about anything that could hurt your decisions or your business or your view. Again, that extends even after our relationship is over. What I mean by that, let's say that you gave me a 6-month listing and you told me you were having marital problems and financial problems. Then we consider that personal and confidential information. Let's say the listing was for 6 months. Let's say at the end of the 6 months, the house did not sell and our contract was terminated for the listing. So you go list it with someone else, and like 2 months later, your house is on the market, and I have a buyer client, and they want to see your house that I listed, over 8 months ago. Even though the original seller was no longer my client, I cannot disclose to my new buyer client anything that was told me personal and confidential from the previous relationship. Even though it's over, I cannot. Because my loyalty to my client is 100%, and I take it to my grave. You need to remember that. So it doesn't matter what phase of the transaction we're in. We're in the beginning, we're near the end. It doesn't matter. Our loyalty is utmost to our clients. We never do anything to hurt our clients' interests. You will be questioned that through your material. Even if we have a ratified contract, a contract is ratified, and we're just waiting to close. And then I find out a couple of days before closing that my clients, the price of their property, just city assessment or the value of it is going to go skyrocket. I still have to tell them, even though I know we had a contract, a ratified contract, and waiting to closing, but anything I know that's going to affect their decision making, I have to tell them, no matter what phase of the transaction we're in. This thing about this Virginia law, this national Chapter 7, where it's agency and fair housing and stuff, I want you to remember it's a real big deal because it's covered a great deal more than any other chapter in your final. And also it's covered again in Virginia law. So you're going to get it twice and a lot of it. So please try to get as much out of these chapters as well. A firm, we're talking about escrow accounts or firm's accounts, what we're talking about now in general. Let's say we are opening up a brand new real estate firm today, and you are the new agents, and right now you don't have any clients or customers, you don't have anybody. So we open up the new firm, and we have to go to the bank and open up the firm's accounts. So one account we may open up, we may call it operating account. And this operating account is where we pay bills, agents, the firm's expenses. Let's call it the operating account. But we have to set up another account called an escrow account. And an escrow account is where we put clients and customers' monies at. So anytime a client or a customer gives us monies to hold, whether it's earnest money deposits, security deposits, down payments, any kind of money that a client or customer gives us, we must put in that escrow account. That's where it goes, in that escrow account. So clients and customers' monies. Now, if we're opening our real estate firm today and we have no clients, so we have to put some money in the operating account because most banks require you to put money in an account to open it. So to open the account only, we may take some money from the operating account to put in the escrow account to open it only. So we take some money out, let's say we take $1,000 out of the operating account to open the escrow account. The next week, let's say you have a client, a ratified contract, they give you a $500 earnest money deposit or EMD. Now that $500 earnest money is customer client's money, so that money will go into the escrow account. And this $500 is going in the escrow account where there's always already $1,000 of personal funds. So at this point, when we get ready to put that 500 in, we must take that 1,000 out because you can't mix the two accounts. So the moment we put customer clients money in the escrow account, we need to make sure that there is no other monies in there other than customers clients. So the only time you can put operating money in the escrow account is to open it. But then once you put clients and customers monies in there, then you have to take that money out. Leaving that money in is called commingling. And commingling is illegal. Can't do it. Commingling is illegal. So commingling is mixing personal funds with client customer funds. That's what commingling is. Cannot do it. Okay. So a couple of bullet points. Only time you can put operating funds in the escrow account is to open it. Once you put client customer funds in there, you take them out. Leaving them in there would lead to what we call escrow violations. According to our current contract, once the money is put in the escrow account, or current Virginia law, there's only 3 ways that money can come out. Once it's put in the contract ratifies the existence of the funds, and the contract says the funds go into the escrow account, then there's only 3 ways that money comes out. Our favorite way is that the transaction closes because it means we're one step closer to getting compensated. Or if the second way that money comes out, if all parties agree to in writing of it coming out and who is to be dispersed to. Again, 3 ways it comes out. 1, the transaction closes. It comes out because the transaction is over. The transaction doesn't close. All parties must have a written agreement as to it coming out and being dispersed. If it doesn't close, there is no written agreement, and someone still wants the funds, then they have to take it to court. Please remember that those are the only 3 ways that the funds come out of the escrow account. The firm was talking about, one of the pages was talking about the types of listings you have. And here's kind of like my short version of it. In an open listing, you would have unlimited signs, meaning you can have 10 real estate firms with their sign in the yard. The catch with this open listing thing is that, let's say I'm the seller. So I tell 10 firms, all 10 firms, you put your sign in my yard. But I, as the seller, I'm also telling you, I will only pay that one firm that brings me the buyer. So although 10 of you got your sign in my yard, I will only pay the firm that brings me the buyer. But more importantly, if I, the seller, find a buyer, then I'm not going to pay any of you. So again, open listing, everybody put their sign in the yard. I will only pay the firm that brings me the buyer. And if I, the seller, finds a buyer, I'm not going to pay any firm. That's called an open listing. It's not our favorite, as you might gather. Another type of listing we can have is called exclusive agency listing. And the difference here is exclusive agency listing will just have one sign in the yard, just one. But that firm will still not get paid if the seller finds the buyer. One sign though. but the firm still does not get paid if the seller finds the buyer. So it's better than the open listing, but it's not the best one. The one that most agents prefer is exclusive right to sell listing. An exclusive right to sell, you have one firm that puts one sign in the yard, and the firm gets paid no matter who finds the buyer. So even if the seller finds the buyer, the firm still gets paid. So most firms want an exclusive right to sell listing because they'll get paid no matter who finds the buyer. Next part of your chapter I want to talk about was antitrust laws, and make sure we understand the definition of antitrust laws. What they simply do is protect the free enterprise system, is what they do. In real estate, the two biggest violations are price fixing. Price fixing is you get one or two firms get together and they decide to set rates or fees. Remember now, you need to remember for test purposes, all fees, commissions are negotiated between the parties. There are no per se set fees as far as we're concerned. All fees, commissions are negotiated. So price fixing would be if two firms get together and say, hey, look, we're going to charge everybody 7%, or everybody 8%, everybody. So no matter whether they come to you or they come to me, we're going to charge them 8%, regardless. That's illegal. They cannot do that because it is what the market's supposed to let that amount be determined between the clients and the customers, the clients and the firms, clients, customers, and or firms. The second is the allocation of customers or markets. When we talk about this allocation of customers and markets, we're talking about, let's say two firms get together and say, all right, you take everybody in this city, I'll take everybody in that city. I won't go to this city, you don't go to that city. Or I'll take Hampton Roads, you can have Peninsula. I'll take the South Side, you can have Peninsula. Things like that. I'll take all houses over 500,000, you get all houses under 500,000. So this allocation of customers and markets is illegal as well. So the two biggest violations in real estate is price fixing and allocation of customers and markets. Can't do that under antitrust laws because that protects the free enterprise system, which is one of the reasons that your license in Virginia is good for the whole state. So you can go to Northern Virginia and write a contract, come to Hampton Roads, western part of Virginia, you can go anywhere and write a contract. As well as firms can have their license, their firms throughout the state. Is to keep things open, i.e. and free. Now I'm going to talk about fair housing a little bit. There's a couple of points I want to make about fair housing. The Civil Rights Act of 1866, not 1966, but since 1866, it has been illegal to discriminate in housing based on race. Not 1966, 1866. It's part of the 14th Amendment to the Constitution. It's illegal to discriminate in housing based upon race. So when we're talking about this fair housing violations and we start talking about protected classes is where we are. The first protected, need you to remember the first protected class is race. So irregardless in real estate, you can never discriminate against someone based upon their race. You can never do that. One thing about protected class, as I said to you, I said race was the first one since 1866. In 1968, they added protected classes. So that's a point I want to make to you as well. You can always, they can always add to protected classes. They never take away. So 1968, they added color, religion, sex, and national origin. So they added to the protected classes. But then also in 1968, they put some exemptions. So as far as discriminating in fair housing is what we're talking. But a person who lives in their own house or they're selling their own house can discriminate as long as it's per se not race. The 1968 says you can discriminate based on race, color, religion, sex, and national origin, even though the 1968 Act says you can based upon race. The 1866 says you can't based upon race. So in actuality, you can never violate fair housing based upon race. But if I'm selling my own house, according to the 1968 law, I can determine not to sell someone because of their sex or their national origin or their religion or color or their race, according to 1968 law. So let's just separate. Now, 1866 says no racial discrimination based upon race. Okay. So let's pretend, let's pretend I'm black. Let's say I'm black. So if you were, you could say to me in the 1968 law, Howard, I'm not going to sell you my house, Howard, because you're black. You could say that in the 1968 law, but I wouldn't take you to court for violating the 1968 law. I will take you to court for violating the 1866 law. It's a difference. Now that's odd in the sense is that in 1968 from on, you can say to me, Howard, I'm not going to sell you my house because I think you black. Can't do that, but you can say Howard because I think your skin is brown, or I think you're of African descent, or you're a male. You can do that according to the 1968 law. You can. But there's a couple of big no-nos in this. Not to say, of course, that we're not, favoring discrimination, but you as a licensee can never be involved in the period. So once you're a licensee, if someone wants to discriminate, you have to leave and back away and get out the transaction. Because you as a licensee can never be part of any fair housing violations or discriminatory facts. Two things that are always no-nos. Agents cannot be a part of the transaction, nor can anyone, anyone, nobody can advertise racial fair housing discrimination. So no always agents can't be involved, never advertise. But in 1 to 4 dwellings, your text tells you 1 to 4 dwellings. For purposes later, 1 to 4 is considered residential. Anything over 4 units is considered commercial. So in essence, you can live in a duplex, and you live in a duplex, you can decide who lives in the unit beside you. You can pick and choose who that person is. Or quad, which is like 4 units, and you own all 4. You can pick and choose. Even religious organizations or private clubs, as long as they're not operated commercially, and discrimination is not based upon race, color, and national origin. Then they're also exempt from the 68 law as well. Meaning, if I had, let's say, I was Catholic and we had a campgrounds for Catholics only. Well, as long as I'm not operating that per se camp commercially, then I could have it just for Catholics, providing that Catholics is not based upon a race, color. Being a Catholic is not based upon a race, color, or national origin. Or let's say I was the Moose Lodge, and anybody can be a moose. So long as we don't operate these commercially, we can limit it to those members of our group. I said to you earlier that they always add protected classes. In 1988, they added handicap and familiar status. We're going to talk about handicap a little bit more coming slide, but familiar status is simply families. You can't discriminate with those with families. Those with family also include women who are pregnant and or couples who are trying, or anyone trying to adopt. A couple of other fair housing discrimination is like blockbusting. Blockbusting is panic selling. Here come the green people moving in your neighborhood, or the purple people moving into your neighborhood. You better sell, because here come the purple people. Blockbusting is panic selling, trying to coerce people into selling their house for the fear of someone or some particular race or group is coming into their neighborhood. Another one is called steering. Steering would be like if I said to you, and here in Hampton Roads, I want to buy some waterfront property. And you said, Howard, we have waterfront property all over down here in Hampton Roads, but I don't want to show you the waterfront property in Norfolk. I want to show you waterfront property in Virginia Beach. This is the agent talking to the client. That would be steering unless my personal requirements was to look for water in a specific city. They should show me all waterfront property to meet my requirements, and not the agent individually dictate what I'm going to see or what I'm not going to see based upon what they like. It should not be based upon what the agent likes, but based upon what the client's preferences are. The last one is redlining. Redlining you normally see with banks. Redlining is just because you want to live in a certain area or neighborhood, the banks would charge you a higher interest rate. Had nothing to do with your credit worthiness. It was just that you wanted to live in a different area, and the banks would charge. Most of these communities we found with those communities with high minority makeup or and older neighborhoods. But blockbusting, steering, and redlining, they hang out together on your test. So make sure you understand the difference between the three. Again, this chapter 7 is important because you have it in the national portion, and then you want to have it again in Virginia law. But I need you to remember what the definition of the handicap is. And that is a handicapped person is one who has a physical or mental impairment which substantially limits one or more major life activities. So the definition of handicap, that's the definition of it in the national portion, and that would be the definition of it in Virginia law as well. His handicap can be extended to when you look at handicap in a different way, things like service animals. Service animals, sometimes we think of just maybe being a dog, but over time, service animals have changed to be other things like ponies or snakes or rodents and stuff. These things could be service animals. So be careful how we deal with these things in your everyday business. An exemption to the familiar status, and remember familiar status is families, is those communities that are intended for older persons. There's two types. Again, these provided for the elderly by either state or federal agencies, right? State or federal agencies. Then they have the two-pronged thing. Either have everyone in there, I call 100% rule, meaning everybody who lives there has to be 62 years of age or older. I call it 100% rule. The second one is in at least one unit, one person, at least 55 in each unit and 80% of the units. So in 80% of the units, at least one person lived there has to be 55. That's what we're talking about. And you can't just pick this building to say this is for older persons. It must have the facilities and services to match as well, such as and other services, dining services, recreational services, and stuff like that. Medical services. These facilities need to have those things as well. It's not that easy. So again, I didn't want to take up too much of the time, but I just want to talk briefly about Chapter 7. And again, to emphasize that it's a big deal in your national as well as your state portion of this course. If you have any questions, you can email me. If you go to our website, and at the link at the far corner, there's one of the links says RE Counselor, and RE Counselor is Real Estate Counselor, which is just me. If you click on that link, it'll email me directly, and I'll be more than happy to answer any questions that you may have. Or my email address is hwilliams with an S at alphacollegeofrealestate.com. I hope this has been beneficial to you. You can view it at any time, and I'll be seeing you in the future. Thanks. Bye-bye.